thank you everybody for getting on the line, and we appreciate you taking time to join this webinar. I see you all are muted already, so your training has paid off over the past few months. If you have any questions, though, please just use that chat feature, and we'll be monitoring that during the presentation and at the end. And with that, I'm going to turn this over to you, Scott, and I thought maybe you could do the introductions to the team that you have presenting today.
Thanks, Hope. Thanks, everyone. There's been a lot going on since we last spoke back in the end of or beginning of April on the business interruption claim. So what we wanted to do is give everyone an update, and if anyone has any follow-ups, we're going to take questions in the chat as we go along, and feel free to reach out to any one of us after. As far as who's on today, it's myself. I'm with the law firm of Schmidt Kramer in Harrisburg. Jack Goodrich and Lauren Nichols from Jack Goodrich PC in Philadelphia. Jim Haggerty and Suzanne Tighe from Haggerty Coopersmith in Philadelphia, and Jon Shub, who's now with Shub Lawyers in Jersey and Pennsylvania. We've been doing all of the cases together. Right now, I think we're up to about close to 200 businesses on these claims, and we wanted to try to give everyone an update, what's going on, a little bit about the numbers involved and the breadth and scope of how the cases are being litigated. So just by way of background, going into, as of 2018, the insurance companies had been making $60 billion profit a year, if not more. And there was a surplus that they were sitting on of $819 billion. It was so much going into this that once the pandemic started, State Farm gave back premiums to auto policyholders during periods of time that they wouldn't be using their cars that totaled $2 billion the first month, and it was basically a drop in the bucket. So there is a lot of money that the companies had been making, and they've basically been sitting on over the years. As far as how much is involved, back at the beginning of the pandemic, the National Association of Insurance Commissioners asked all the insurance companies, they did what's called a data call. And a data call is something where all the insurance companies are asked throughout the country to send in certain answers to questions as far as how much premiums they're writing for business interruption, how many claims they may have, how many claims they may not have, what has exclusions, what doesn't have exclusions. As of June 20th, when the data call came in, just with premiums that have business interruption insurance, there was $9.9 billion in this year of premiums written just for business interruption coverage for the company. So they've been bringing in a lot of money just in and of itself for that coverage itself. Moving forward, as far as COVID-19 claims, the companies were asked how many policies actually had business interruption coverage potentially. And just with small businesses, and that was 100 or fewer employees, there was medium-sized businesses and then large businesses. There was 6.9 million policies out there that had business interruption coverage. In the policies, and we're going to get more into what a physical loss is later and things like that, 98% had the same type of language that requires a physical loss of or damage. So basically almost every policy had that. And this is important with the exclusion, at least the insurance companies said of the policies that were out there, 83% had some type of exclusion. Now, it doesn't say whether it's a virus exclusion or a bacteria exclusion. And unfortunately, a lot of companies are not aware that when you're denied the claim, or businesses, when you're denied the claim based on the company saying there's no physical loss or there's an exclusion, you still need to pursue the case and preserve the case, because assuming we win and we're successful, you don't want to end up with a situation where the company, insurance company, turns around and says, by not reporting it or not pursuing it, you actually prejudiced your case and are not allowed to move forward. We're taking and we're pursuing cases with the exclusion as well, because we have a different ways that we do not think it applies, specifically that some of them have bacteria exclusions, and bacteria is not even remotely close to a virus in this case. There's also some other numbers that popped up, is just in June and July, there had been 155,770 claims reported to insurance companies. 134,000 were closed without payment. That means that the companies, the businesses either accepted the agent or the company's statements as the gospel that there's no coverage, and then they said, all right, fine, and then they allowed them to close the file, or just that's basically they're not out there. They still need to be pursued, so you don't want to let the claim get closed. Of the claims that were made payment and closed, which means they made some type of claim, whether it be for an event or like $1,000 or something, only 14 out of the 155,000, or 0.89%, as of July 8th had been paid. So basically, no claims are being paid. If you bring the claim, when you bring the claim, make sure you follow through and force the company to open the file and give you a denial letter so you have that documented. Now there's a different positions that are going on. There's different issues and different policies, and we'll talk mainly about business interruption and civil authority, but there's also event cancellation and business policies, where if you own a wedding hall, or you may have had fundraisers that generally were booked at your restaurant, those types of things, if they were generally booked and then they were canceled, it may also be covered under event cancellation. Or if you had certain events that were planned for weddings or bar mitzvahs or confirmations, and they were canceled, those also would be subject to it. Travel insurance, workers' compensation, directors and officers, and errors and omissions. So you want to look at those things, but generally for the purposes of today, even though we do have certain other cases for event cancellation, we're looking at the business interruption and civil authority. What you generally want to do is look it's generally part of a commercial property policy. It's not going to be covered under your liability policy generally, and it's also not going to be covered under a workers' compensation or liability policy. It's generally going to be the commercial property policy, and business interruption is generally for the business owner or even the property owner if you lost rent, things like that. It does not necessarily need to be an essential business. It's any business that's been impacted in any way. So it did not have to be a total shutdown. It could have been a partial shutdown or any way that your business was decreased because of the pandemic. And also farms, a lot of them were also impacted because they lost a lot of business from restaurants that were closed or canceled, orders, and they're part of the supply chain. So that may also be a business interruption issue that you want to look at. The different types of businesses, again, restaurants, bars, hotels, amusement parks, casinos, a lot of bed and breakfasts. Particularly, you may have, if you have a bed and breakfast or a hotel or a bar, or restaurant up around in Penn State or for college football, where that's going to be impacted, it could potentially be a case. Convention centers, golf courses, campgrounds, any type of business, dental offices, physical therapy offices, those are all the types of businesses, and there's a lot more. The general issues that you're looking at and that are subject to the litigation, and we'll get more into the positions, is you need to show a physical loss of or damage. And the physical loss of can be interpreted two ways. One, it can be interpreted your physical losing your premises to be able to use it, just in general, the full use of that you can't do 100% of what you were doing, or the physical loss is damage. That's what the companies are saying. And Jim and Suzanne will talk a little bit about what the positions are, but generally the law in Pennsylvania is that if the insured, meaning the customer, has a reasonable interpretation of a provision and the insurance company has a reasonable interpretation, basically the tie goes to the business. The business should get the coverage. So the business is kind of like in baseball where it says tie goes to the runner. The business gets the tie and should recover. Damage is pretty straightforward. There's also losses, damages, and expenses. And those could be all different types of claims. But for the threshold issue at this point, it's generally been physical loss of or damage. There's also what's known as civil authority. And civil authority, which is on the next slide, basically talks about if your business is impacted because of a government order. So basically you can't use your premises fully because of the government order. That could be the shutdown for a period of time. You don't actually need physical damage. So this could be something where your suppliers are shut down and you can't use your whole business, or your waiters and waitresses cannot get to the premises for one reason, because they all have COVID or are concerned. You can make a claim for civil authority, and that's generally more limited in time and scope, but it still allows you to recover for losses, damages, and expenses. But generally what's been happening, as we'll see, is all the companies on the next slide have been denying the claims. And Jim's going to talk about how the policyholders have been taking a position going on this, because I think I took his portion.
Okay. And that's why we work together. Okay. Okay, I'm Jim Haggerty. I just want to talk about some of the coverages and some of the issues. What we need to keep in mind is that these are property policies, as Scott pointed out. So it's the coverage arises from loss of or damage to the property. That's the main issue that the carriers are focusing upon. This is essentially an issue of policy interpretation. So the policy provides coverage. There are then certain exclusions. So first, what we have to do is, in looking at this, we have to analyze the coverages that are available, and is there coverage under the policy before we can get to whether or not any of the exclusions are applicable. As Scott pointed out, these are property policies. Generally, they'll cover fire, damage, whatever would be normal in a policy. In a restaurant, the normal situation would be, okay, I have a fire in the kitchen, got to shut down the restaurant. There's damage to the property. There's loss to the property. I have to shut it down. I get my lost profits while they're repairing it, and they pay to repair it. So among the coverages are business income. There's also some extra expense during the period of time when you're repairing it. Civil authority, as Scott mentioned. There's also additional coverages, which he mentioned, also including contamination if you're a restaurant. But the policy, we look at the coverages. Is there coverage? And the policy requires that there be physical loss of or damage to the property. So what the carriers are focusing on, they're saying that there is no physical loss of or damage to the property. And that's the first part of our fight. And as Scott pointed out, in interpreting insurance policies, the court's duty is to look at it and determine if there is an ambiguity. There is an ambiguity if a policy provision is subject to 2 or more reasonable interpretations. So if our interpretation as a policyholder is reasonable, then as Scott pointed out, the policy then, that creates an ambiguity because our interpretation is different than the insurance company's interpretation. If they are both reasonable interpretations, the policyholder wins because the policy has to be construed against the person who drafted it, the insurance company. As he said, the tie goes to the runner in that situation. It's not a question of is the insurance company's interpretation more reasonable? It just means, is our interpretation reasonable? Is it not absurd? If it is reasonable, then the courts are obligated to find in favor of the policyholder. So the first question is physical loss of. What does that mean? Is there physical loss of? Well, we know that if you're a restaurant, you haven't, because of this situation, you haven't lost the restaurant. We know where it is. It hasn't burned down. It hasn't been misplaced. The restaurant is there. So loss has to be reasonably interpreted as loss of use. There's a loss of use, and if there is a loss of use, we believe that's a reasonable interpretation of the term loss of. Now, some policies say physical loss or damage to. The fact that they've inserted the word loss of the property in most policies. Loss of the property means reasonably loss of use of the property. I haven't misplaced my restaurant. I just can't use it. So the insurance companies are saying there is no physical loss. They're also saying there is no damage to. There's no physical damage to the property. Now, again, we're maintaining the position that although it's loss, it's in a disjunctive. It can be loss of or damage to. We're arguing that there are coverages under each. There's damage to the property. An example is I own a restaurant and it's on the Gulf Coast and there's a hurricane coming. So I shut down my restaurant, close it all down, and I leave. The storm comes through. My restaurant was not damaged, but I shut down because of the hurricane. So did I have damage to? Is it damage, actual damage, current or future anticipated damage? There's no question that I closed my restaurant because I was concerned about the hurricane coming. Do I actually have to have that damage too? Not unlike the pandemic and the orders of the government saying we're shutting down everything because you are going to get infected. You are going to get struck by the hurricane. So we're shutting you down. So we're taking the position that that's a reasonable interpretation. Damage to. Another example we've made in some of our filings is you own a factory, you manufacture machine parts, you have a big machinery working, and one of your parts is wearing out and it's going to break. You order a new part, but you have to shut down the operation while you're waiting for the new part. Do you say, I don't have any physical damage because I recognize this is not going to work, and I shut everything down so it doesn't shut down the whole operation and break other parts? Do I have to wait until that part breaks and then I have physical damage and other losses before I can make a claim? No, that's senseless. So we're arguing in this situation, this is the same type of situation, that the anticipated damage, that there is loss of or physical damage to. We're arguing that we don't have to prove that there is actual, the virus is not present in the restaurant or the hotel or the bed and breakfast, that it's not unlike the hurricane's coming. The COVID-19 is coming, so therefore we have the damage, current or future. You want to keep in mind then, when you make a claim, and it'll be pointed out to you that's important to make a claim, the insurance company may try and, insurance companies used to be in the business of paying claims. They're not in the business of paying claims anymore. They're only in the business of making profits. So they may call you up and say, oh, I got your claim. Did you have any physical damage to your restaurant? Well, just don't answer the question, because you'll say, well, no, I don't have any physical damage. Then I'll write you a letter and say, well, you've confirmed that there's no loss or physical damage to the premises, so therefore there's no coverage. Don't answer the question. Say, I don't know. I don't know if the place is infected or not. There could be, I certainly have lost use of it. There could be damage to it. I don't know. I haven't had an epidemiologist inspect the premises. There could be, yes, I believe there could be. There's definitely loss of use, and there could be physical damage. I don't know. I don't know the extent of this pandemic. But don't answer that question. Either say, talk to my lawyer, or just avoid it, or say, yeah, I think there is damage. Civil authority is similar. We have the business income, which covers at civil authority, very similar coverage, but it's when there is physical loss of or damage to as a result of civil authority orders entered in connection with different issues. They're going to raise the same issues: physical loss of or damage to. So you want to be aware of that. Many of the policies also, as Scott mentioned, not all, but many of the policies have a virus exclusion. And the question is, how does that virus exclusion apply? Some policies, as Scott pointed out, only have a bacteria exclusion. And we're taking a position where the virus is different than a bacteria. That doesn't apply. If there is a virus exclusion, we're also taking the position, it's interesting, the business income, the civil authority, and other coverages provide coverage for loss, damage, and continuing operating expenses. The virus exclusion excludes losses and damages. So we're taking the position that even if this virus exclusion applies, and it may well be that the courts may find that the virus exclusion applies to this situation, it only excludes losses and damages. You still have your continuing expenses. You still have to pay your mortgage. You're still paying your electric. You may still be paying your employees. These are normal operating expenses that you have a claim for because they're not covered. So we want to keep in mind it's a two-step process. First, is there coverage? And we're taking the position that there is coverage under the policy, that our interpretation is a reasonable interpretation. There should be coverage. Is the coverage then excluded? Well, if there's a virus exclusion, if that exclusion is applicable, it does not exclude coverage for continuing business operating expenses, which can be significant. It's not as significant as your loss of profits, but there is still a coverage there. And as Scott pointed out, when you make a claim, when you speak to your agent or your broker, he will say, oh, there's no coverage for this. That's different. There, you have to find out, well, what are you telling me? Are you telling me I do have the coverage under the policy, but you're telling me it's not applicable, rather than you have no coverage? What they're telling you is, well, I don't think it applies because you have no loss of or damage to the property. Well, don't listen to your agent or your broker, because most of them don't know that much about insurance coverage anyway. That's what the companies are telling them. Have them make the claim, get a denial, and then you move forward from there. So that's basically the issues that you're dealing with here. You want to present a claim. It turns out to be a question of law. There's really no questions of fact here. This is an issue that really you're going to have to put into suit. They are not going to voluntarily pay these claims. That's just not going to happen. And that's why we're filing individual claims and we're filing class actions, because the insurance companies are going to fight these. And unfortunately, these cases will have to go through the trial court, to the Superior Court, to the Supreme Court, because these are novel issues. And we're, in the cases that we're handling, we're trying to tee up, as these gentlemen will tell you, trying to tee up these legal issues so we can get them to the Supreme Court as quickly as possible to get them to address it, because people are hurting. You know, we need these to move quickly through the courts, more quickly than normal, so that business owners can get some relief. And that's what we're trying to do. Here. Thank you, Mr. Cooper.
And also, one of the things, Jim, can you explain how these are occurrence policies? Someone asked about that if they haven't opened one yet, could they still file today, and then it's basically backdated to March when they closed? Yeah,
sure. There are two kinds of insurance policies. There's an occurrence policy, or there is a claims made policy. All of these policies, these property policies, are occurrence policies, so that if there is a loss that occurs during the policy term, let's say it's January 1, 2020 to January 1, 2021. If there is a loss that occurs during that policy period, it's covered, even if it's not made until after the policy term. A claims made policy, and they're more likely to be errors and omissions coverage types of policies, malpractice types of policies. The policy in place at the time the claim is made occurs. That's not usually the case with a property policy. So you can make a claim now for something that happened. Auto policies are claims made policies. I could have been in an auto accident a year ago and no claim was made against me. I ran into somebody and I didn't hear anything. The statute of limitations is 2 years. If a year goes by and then all of a sudden they sue me and I send it to the insurance company, it's the policy in effect at the time. Even though the claim is made a year later and I may have different insurance coverage, the policy in effect provides coverage. So yes, that policy is in effect for the period of time when the loss occurs. When would the loss occur? The loss here would occur, probably the onset would be when the government issued its various orders shutting everything down.
Thanks. And Jack, I wanted to, you're going to talk about opening the claim, but once the claim is opened and they have the denial, is it considered open, or do they have to refile, or what should they do once they have the denial?
Well, once you have a denial, you've obviously put the insurance company on notice of your claim, just like what Jimmy was saying. At that point, you do nothing, or you contact us, because within the denial letter, the insurance company will set forth their positions as to why they denied pursuant to the policy. And they have to, within that denial letter, give all the reasons why they're denying your claim. I mean, you could call and say, look, government shut me down. I believe I have business interruption insurance and I want to file a claim. It's up to the insurance company then to set forth within the policy where there is potential coverage, and then they specify why you do not have coverage. And the reason that is very important is so that they can't come back a year or 2 years from now and try to fabricate another reason why you don't have coverage. Within that letter, it's very important because you're hand tying the insurance company as to the reasons and their basis. They must give a basis within the policy why it does not apply. And this is what we are seeing repeatedly again and again. It's not too late to file a claim today. It's not too late to file a claim tomorrow. Not too late to file a claim in a month. But the sooner you file the claim, the better off you're going to be. What I am starting to see right now, and I'm actually waiting, I just had another potential claim, Erie policy yesterday. Now they're attempting to send out a very lengthy questionnaire that they're trying to get the policyholders to respond to. And just like Jimmy said, my position would be, you don't respond to it, or contact us and let us respond to it. Because this is, to me, it's chicanery. They're just trying to find another way to say no.
And Jack, if someone already answered the questionnaire, I'm assuming they need to call a lawyer to make sure that gets changed.
Correct. I mean, that happens often. It's just like when you take a deposition and they give you an errata sheet, which is you review your deposition for its accuracy. You can go back and look at it and say, that's not really what I meant. That's not what I understood, where I misunderstood something. You know, you're dealing with legal terminology, not just plain speak. When you got two people sitting in a bar or a restaurant, they're talking. The insurance company is lurching on every word to try to find a reason not to pay. And just because you state something within this questionnaire does not mean you're going to be excluded. Because as Jimmy said, and as Scott, as you said, and we've said from the beginning, it's physical loss or damage. It doesn't say and damage, it says or damage. So it's one or the other. And damages can be a lot of different reasonable terms. We as lawyers argue damages all the time, which could be wage loss, economic loss, physical pain and suffering, property casualty loss. There's a lot of things that go into what an actual damage is. So, you know, the best thing to do is always, only a fool has himself as a client, is what I was told in law school. You know, I'm not a mechanic, I'm not a medical doctor, I'm a lawyer. Let the lawyers do the lawyering. And that's the most important thing you can do.
And as you were talking about,
sort of like Scotty on Star Trek.
Right.
the lithium crystals. And then as Jack and Jim were talking about the companies, how they're denying the claims, Suzanne, could you cover the insurance companies, basically what they're doing?
Oh, sure. And thanks, Scott. As you and Jim and Jack have pointed out, the insurance companies are uniformly denying the claims with little or no investigation. And they're doing so by relying on the terms on the face of the policy, holding that there was no physical loss or physical damage to the property. I think one of the important things to point out is those terms are not typically defined in the policy. Despite that, the insurance companies are applying a really narrow definition to those terms, requiring actual tangible physical loss. So essentially, the insurers are denying the claims on three broad bases. The first, that there's no physical loss or physical damage. The second, that there has been no prohibition, that the civil authority orders, number one, there's a couple of defenses that the insurance companies are asserting to the claim under the civil authority. First, they're arguing that the businesses weren't actually shut down by a government order. It was rather a recommendation. And I don't know how far they're going to go with that claim. Secondly, they're also revisiting there was no physical damage. There was no presence of COVID in the building. Therefore, the building and the area around the mile around the building were not subject to the actual civil authority order. Then the next is the virus exclusion, as you guys talked about. The policies may or may not contain various virus or bacteria exclusions. And they're just saying, listen, this they're not doing the nuanced interpretation that Jim and Scott have talked about, where they're saying the virus exclusion excludes only certain claims. They're saying it excludes all claims. Finally, some policies will have a force majeure provision, which will exclude coverage for things that were not anticipated by either of the parties. And I think that, if there may be an argument against that, being as some policies have virus and pandemic exclusions. So I'm not sure how the pandemic can be an unanticipated event where other companies were putting in the language. And finally, I mean, frankly, the insurance companies are doing anything to avoid paying. They're not investigating the claims. I think the numbers that Scott discussed in the beginning are rather startling, and the questionnaire that Jack has pointed out today just goes to show how they're not doing the investigation, and they're hoping to sort of, lead you into denying your own claim. But that's where we're at with the insurance companies.
Thanks, Suzanne. And so what I think you're going to see now is, unfortunately, like Jim said, what we're trying to do is move forward with these cases as quick as possible. And there's been some movement in the last few months. The main cases would be in Pennsylvania, and Jack's going to talk about them. Tambellini versus Erie, and Hungarian versus, it should be CNA versus Valley Forge, not CAN. So Jack, can you bring people up to date?
Certainly. Real quick, a little minor correction when the introductions came on. My law firm is actually in Pittsburgh, not Philadelphia. We are throughout the Commonwealth, which is important because we can handle any and all cases. The Tambellini case is actually filed in Allegheny County. The Tambellinis are actually neighbors of mine in the Northern Hills of Pittsburgh. And Tim Hungarian is a dentist who's a friend of mine. They are filed in Pittsburgh along with multiple cases throughout the Commonwealth. The Tambellini was the first case filed in Pennsylvania in common pleas court. The reason it was filed in Pittsburgh was because they're residents of Pittsburgh. They own a family restaurant, just like a lot of you people that are on the phone today, and their heart and soul are in that case. Tambellini's was filed. We've had Erie dragging their feet on this case. Tambellini's case, real quick, going back for a second. Missy Tambellini called me on the phone and said, "We've been denied. I guess there's nothing we can do." And I said, "Well, was it a written denial or a telephone denial?" And she said it was a telephone denial, which prompted me to tell her, make sure you get a written denial so that we have the basis and the specific reasons why they're representing you're not covered. And again, as we've seen scenario case and case again, it's the exact same scenario ad nauseum, no physical loss or damage to the covered property, which again, we're not going to go through that. We believe there is, and we've believed that it has been since day one, even though all the naysayers have been telling us no. Tambellini's right now, Erie has filed an appeal on that case. My office has probably filed 30 cases right now against Erie, and they keep coming in every day, and we just keep mounting them up and getting them together. We also have, by the way, we have car dealerships also that have had substantial damage because of the damage, and they are also Erie filed cases. So right now we're trying to push the Erie case through the court. It's on appeal. The judge has already issued an order asking Erie to state within probably about 15 days now left their basis of the appeal. And we're going to hope to get this expedited to either Superior Court or potentially move for a King's Bench, get it straight up to the Supreme Court of Pennsylvania to get a ruling, because we need to get a ruling on whether or not the policy provides coverage. And there's three bases, as Jim and Scott have talked about already, as to why we believe there's policy coverage for the expenses, income loss, and business loss. The Hungarian case has been filed in Allegheny County, and the defendants have filed an answer in new matter, which is a response to the complaint itself. And we are discussing these cases every day. I mean, I don't think there's a day that goes by that I'm not talking to Jim, Scott, Jonathan, if not once, twice, 3 times a day about how we're trying to move this forward, because it's very important to the policyholders, small businesses that make up over 75% of this country, is the backbone of this country, and they're not getting any help. I mean, you're getting maybe PPPs or maybe a small business loan, but that's not going to keep you afloat, and we're trying to move those forward. So that's where we're at right now. CNA, we're going to be moving that forward. Hopefully, get the judge in the Court of Common Pleas of Allegheny County to give us a decision soon, and hopefully we can move forward and get some very needed help for you, the policyholders. Scott?
And one of the things, I don't know if you could talk real quick, and we have been successful on some of these motions, like Jack said, with the coordination, but you also want to try to be in state court versus federal to move the case quicker to get it to the state Supreme Court. And because that's who's going to make the ultimate decision. And in one of Jack's cases, he was successful yesterday with, you want to just talk about UNAMI, where they moved it and we beat the company to get it back?
Sure. The other thing that we find on a lot of these cases is the insurance companies are trying to move them to federal court. Now, there's no legal precedent on this issue. And our position has been that this is not a federal issue. This is a state issue, which means it's state law that applies. And we've been successful on multiple cases, and we're starting to see a trend. Federal court saying that it does not apply to our courts. This is a state question of law, and therefore they're kicking it back or remanding it to state court. And it's for the Common Pleas Court of Allegheny County, where a lot of this fighting is going to happen, should make the ruling on whether or not there's coverage that's applicable. And I think we've seen 2 or 3 of these kickback, and we expect to see a tidal wave of them all coming back to state court. And we, again, are on the forefront of all these cases in the Commonwealth. Now, I saw that there was a question, is it too late to join a class action? No, it is not. If that is your policy through one of these cases that we filed, and we filed against multiple insurance companies, it's not too late. All you have to do is get a hold of one of us. Scotty will give you our website. All you have to do is Google us, and you can find us and contact one of us, and we can get you out the questionnaire, get you signed up. And remember, there's no risk here. If we're not successful, you don't owe us anything. We're taking the risk. And hopefully it's going to be a well-founded risk, and that's going to help everybody out. But it's not too late to join a class action, because the class action affects anybody with that policy or similar like language. Damages may be different, and we can figure those out after we get the coverage issue, but it's never too late to join. You're mute.
If you end up in federal court, there's a series of cases now, what's known as an multi-district litigation, where the class actions in federal court, they're trying to join those cases. And John, can you just give an update on what's happening there?
Sure. So last time we had this conference, there was a motion filed by lawyers around the country to try to get all these cases in one court around the country for all the insurance companies. Lawyers for plaintiffs that were bringing these cases wanted to try to get these cases in either basically 1 or 2 places, all in Philadelphia or all in Chicago. And there was a hearing before the panel called the Multidistrict Litigation Panel, which is a federal program that the federal judges run, where they take cases that they think are appropriate for coordination and they put them to one judge. The 2 tests for whether there should be, it's a 2-prong analysis. One is, should there be coordination? And 2, if there should, what court should it go to? Well, we never got to the second prong, what court should it go to, because the federal judges a couple weeks ago declared that these cases are not appropriate for coordination before one judge. There are too many defendants, too many different policies, too many state laws that apply. So the court left the cases where they were currently pending in all the different federal courts across the country. The judges did, though, allow several companies to sort of reapply for coordination, but it wouldn't be before one judge for all the cases. It would be by defendant. For example, Erie would have one judge, and CNA would have another. Selective Insurance would have another judge. Right now, that is still pending, so we're not sure whether there's going to be a multi-district litigation for each specific defendant before one judge. We do know there won't be one judge handling all of these, though.
Thanks. And as far as some cases, there has not been a case specifically in Pennsylvania, but there's been a few in DC Circuit Court, Roses versus Erie. They lost that, and the judge said there was no coverage. There was one case out of a federal case in Missouri where last week the judge said that the case could go forward, but there's other issues that are going on. There has not been one definitive case. And one of the things, and Jim, I'll just ask if you could comment on this. Someone asked is there a statute of limitations? And is someone better off waiting and see how the cases turn out, or if they should still pursue the case and how to go about it, considering there's only a 2-year statute and it could take 2 years to get to the Supreme Court?
Yeah, certainly you can, it's your option if you want to wait and see how it plays out. But yeah, you may run the risk of having your claim barred as being untimely. You also, we have cases where we filed, for instance, with Erie, we filed individual cases. We've also filed a class action. We're filing the class action would include you. If you are an Erie insured and your claim has been denied, your claims are protected because you would be a member of the class if, first, we prevail on the legal issue, and secondly, a class is certified. So you would be protected. In the event, however, that there is no certified class, we are filing individual claims to protect those persons so that the statute of limitations, by filing an action, it tolls or halts, tolls, T-O-L-L-S, tolls the statute, meaning it stops it from running when you file an actual lawsuit. So your claim is then deemed to be timely. You can wait in the event that a class is, that we prevail and a class is certified. If a class is certified, it may be, you may be out of luck by that time. Unfortunately, it's going to take a while to get these cases up through the courts, and we're going to have to go to the Supreme Court to get a final ruling because the insurance companies are required under law to pay claims promptly and fairly. The reality is, if you want prompt, it's not fair. If you want fair, it's not prompt. So they're not going to pay these claims voluntarily. They're only going to pay the claims when a court makes them. That's the reality of it. And so you can certainly sit back and wait, but you also have the option of filing the claim and making sure it's preserved.
Thanks. And then, so to
Basically, just like what Jim said, I found in life you're better safe than sorry. It's not gonna hurt to file the claim now. That way it's preserved, like Jim said, if there's no class certification.
And I was going to turn to you now as we're finishing up. If you could kind of give the thumbnail checklist of what people need to do to preserve the claims in order to not be stuck with being barred by untimely filing. Basically the making of the claim process, which is on the next slide.
certainly. Obviously, you have to have an insurance policy to make a claim. You need to contact your agent and or the company directly and file the claim. We have found, I think, probably 99% of the agents all say, as Jimmy said, you don't have a claim. You don't care what they say. I've been told I've been wrong for 35 years, and we keep, and Scotty and Jimmy and everybody, and we keep being found that we're right. You have to make the claim. You tell them that your business has been interrupted by the governor's mandate and edict relative to the C-19. As Jimmy said, if they asked you, do you have the virus? The answer is, you don't know. You're not an expert. You know, you were complying with the government regulations and told to file the claim. So you want the claim filed. You want to make sure that they send you a denial letter. And this is what we're talking about. Within the denial letter, it'll specify the reasons why the insurance company is making a statement that you do not have a claim. And that is very important, because then we take that letter and we basically put it in your file, and then we file a lawsuit, or we follow up with the insurance company in town that we're representing you. The insurance department, you can file a complaint with them, but quite honestly, that's not going to do you much good, because they document and register that you have you filed a complaint. The denial letter calling us is more important. Now, consumer protection, you can also go through a government agency, but all that's going to do is fine the insurance company. It's not going to do you much good. You need to file the claim. And more importantly, we are so far down the road on these cases that we've already retained the experts on the insurance coverage. And they've already given us their expert opinions as to why there's coverage available. And that is how we are streamlining the process and protecting our clients, the insureds that are being told no. The only way that you're gonna get coverage is if we're successful in moving this forward and litigating it in the courts. And again, I can't stress enough, you're better safe than sorry. And retaining us and getting us moving doesn't cost you anything. Quite frankly, if we're successful, the insurance companies are going to be paying money to you and us. And that is one of the most important things I can tell you and stress today. Scott?
Okay, we're finishing up. There's one other piece of business I'm going to ask Jack to comment on, because he's going to be talking about it in a minute, on legislation that's out there, which you want to be aware of. But if you have any questions, email us. Here's our email addresses, and it'll be on the, I guess this is available to watch. As far as legislation, a lot of people have asked what potentially is going to be out there. Unfortunately, and that's the next two slides over, it's going to be hard to get legislation actually passed this year. The one bill that you do want to look for, it was recently introduced by Representative Frank Dermody from out in Pittsburgh, House Bill 2759, and that was a bill he introduced. Basically, it mandates that there would be coverage if there's another pandemic going forward. It doesn't help this time, but at the same time, you know, would cover in the future. And Jim, I want to ask, someone asked a question, and I think this is important. Is a business at risk of being dropped by their insurance carrier if they bring a claim or they sue them? My position is you can't be dropped, or you'd have a bad faith case for them dropping you.
No, I don't think so. It's not a basis. It's not a basis for terminating policies. Frankly, they'd have to terminate, you know, everyone who has a claim. If you have a valid claim, that's why you buy insurance. They cannot cancel you or terminate you for that reason. You know, people also ask, well, is this going to adversely affect my premiums? These claims, yes, are going to have an adverse effect upon premiums because premiums are based upon historical payouts. If in fact the insurance companies are required to pay these claims, they will pay out more money and claims will go up. But that's up for everybody. They won't look at it and say, oh, well, look at these guys. You know, Frank's Fireside Grill didn't present a claim to us, so they're good guys, so we're not going to increase their premium. It doesn't work that way. They're going to increase everybody's premium, whether or not you present a claim, if we are successful in pursuing these. That's the nature of their business. So there's no incentive for you not to file a claim here.
Thanks. And then, Jack, could you just talk a little bit about Senate Bill 1114 and Senator Iovino and Hughes, since that people in Pittsburgh may see that on TV or the paper today?
Yes, actually, I'm going to be on a webcam at 1 o'clock with Senator Iovino and a couple of small business owners that are being adversely affected. The Iovino bill is with Senator Hughes is a bill that has been introduced to try to redefine terminology to define the physical loss or damage to include the COVID-19 in the future, but that doesn't do us anything retroactively. The one thing that I would like to bring up is that the Supreme Court of Pennsylvania, in a case of In re DeVito, has already stated that this type of pandemic is the type of catastrophic losses that are ordinarily and reasonably covered by insurance policies. Now, they've already stated that, and that's one of the bases why we think we're going to get coverage in the future. But again, these bills are prospective. They cannot pass a bill now that's going to go back to March 1st and say you're covered. That's unconstitutional. This is something hopefully for the future. And, you know, all the experts are saying that until we get a vaccine, we're probably at risk of having another flare-up or outbreak. So the only hope that we have right now going forward is the litigation that we're doing. There may be something prospectively down the road with these bills that will cover pandemics, et cetera. And that's what we're looking at. And another point you got to remember, this is not the first pandemic that's ever hit the world. There have been numerous pandemics throughout history. So this isn't something that's new. And another part of our position is that if they wanted to specifically exclude it, they should have put the specific language in. So again, this is the legislation going forward. There may be some help in the future, but you know, we're the help now.
Thanks. And just to give an example, even if they had the word pandemic in there, there's actually one policy in Texas where a movie theater is suing Lloyd's of London, and they actually had a policy for pandemic coverage, and the insurance company is denying the case, saying that they're denying it because it did not have COVID-19 in as a covered disease. It had SARS and H1N1 and all these other ones, but it's kind of like, how do you even going to anticipate if you buy a pandemic policy and it doesn't have COVID-19? So they're going to try to figure out every different way to deny it. So we've been an hour. I know people have to get places. If anyone has any questions, let us know. And thanks everyone for participating.
If we can help you, let us know.
Please.
Is the last slide, does it have your contact information on there?
It has the emails a few slides up.
Yeah, that way we could at least have that up, but you can definitely reach out to us. And I can put you in contact with Scott and he could, you know, forward it to the appropriate individuals. Thank you so much for presenting this update on this information. I appreciate you all taking time out of your day to do this. I know it is, you know, important for our members to be kept up to date of what's going on with this particular part of lawsuits that are going on.
Thank you.
With that said, it seems like we don't have any more questions. We will be sharing this recording and sending it out to the participants and putting it up on our website. And again, thank you all for your time today and presenting to our group.
Thank you very
Thanks
much.
for
It
asking.
was a pleasure.
Everybody have a great rest of the week. Thank you.
Stay safe.
You guys too.
Bye-bye.
Bye-bye.
Bye-bye.